Hello and welcome to tonight's webinar, the 5 W's of Disclosure. It's about 5:30 right now. We're just getting started. We're going to take a second to get our webinar PowerPoint up and running. Just everybody's signing on. This is an oldie but goodie go-to webinar that we're using again, and so we're just getting everybody set up here. So welcome and thank you for attending tonight. Tonight's ethical webinar, I said, is brought to you by Court Language Access Services here in this great state of Oregon. So we're going to just go ahead and get started. The continuing education credits that people will receive for tonight's attendance: for Oregon Court Certified Interpreters, you will be getting 2 ethics credits. For Washington State Court Certified Interpreters, you guys are pre-approved for 2 ethics credits. And then again, the ASL RID interpreters with their SCL will be getting 0.2 RID CEUs for tonight's attendance. Please remember that so in tonight's discussion, hopefully we'll have a lot of participation from everybody out there. We're so excited to have this tonight. We're going to be having different ways that we can interact with everybody, and we'll get into those in a minute. But again, this event is not a language-specific event. It is a language-neutral event, so all of your examples or questions that you have tonight, if you can please keep them in English so that everybody here can participate, that would be great, and then we can share and hear from everybody. Again, this is a live program. It is being recorded, and that means that all the participants, all of your questions, all your comments that we have on the air tonight, that we hear from you out in the big internet world, will be recorded. We make this recording available in the future for other people, so if in the future you need more CEs or ethical CEs, you can always reach out to Court Language Access Services, and we make our recorded webinars available for people so that they can earn their CEs in the future. So we also want to give a special thanks to Kelly Mills. She is our program manager, and without Kelly, this type of programming would not be available. She really supports interpreter services and the work that we do to be professional, and she's one of our biggest, of course she's our biggest ally, but she really goes above and beyond and gives us time and space to continue these CEs so that we can continue to grow our pool of professional interpreters here in Oregon and really throughout the country. And we just want to say thank you and really appreciate her for her continued support for us. Michelle Gearhart is our Court Language Access Certification and Training Coordinator. She is the one that is busy tonight and has been this week taking registration and phone calls and problem solving. So most of you guys have had your one-on-one interaction with Michelle to get where you are here tonight. And always, Michelle is just a great worker and really helps support these types of events for us, and we couldn't have tonight without Michelle. So a big thank you to Michelle. Also, I want to introduce our panel real quick tonight. We have the Honorable Judge Kathleen Weber here with us. Judge, do you want to go ahead and spend some time introducing yourself?
Good evening, everybody. My name is Catherine Weber. I am a circuit court judge in Clackamas County, Oregon. I've been a judge for about 7.5, almost 8 years now. And before that, my practice was almost exclusively criminal defense, with a lot of Spanish-speaking, Russian-speaking, other languages represented within my clientele. I did a lot of court-appointed work during that time, and I've always had an affinity for language. I speak Spanish. I lived in Spain. I've lived in Germany, and I was actually the only student in my high school many, many years ago that wanted to take both Spanish and French, so they had to create a whole new program for me so that I could take honors classes in both. So I love language, and if my career path had been a bit different, I think I probably would be an attendee instead of one of the speakers.
Aw, that's great. Thanks. So also, we are honored tonight to have Lisa Crawford, who's an Oregon certified ASL interpreter here. Lisa, do you want to introduce yourself?
Sure. Good evening, everyone. I've been interpreting for about 26 years. I like to specialize in the court and legal venues, but I've been doing that for about 14 years here in Oregon. I have my specialist certificate legal through the Registry of Interpreters for the Deaf, and also, of course, as Mel has said, the Oregon Court certification. I've been attending these ethics webinars for about 3 or 4 years now. Even though they've been going on a lot longer, I don't know where I was before, but I'm sure glad I'm able to attend them now. And they have been so informative, invaluable, giving us tools so that we can analyze scenarios, it can become more systematic and not be the deer in the headlights moment when we get into the courtroom. But I really appreciate Mel and Ed and Michelle, all the ones who put in so much work to make these happen, because I have found them to be so useful. And anytime I can attend, I attend. I just really appreciate all the work.
Well, we always enjoy hearing from you, Lisa. You always have good insight and comments on our webinars, and so we asked you to be here tonight. I'm Mel Dilliam. I'm the Court Language Access Services ASL staff interpreter. Yeah, I saw there's a couple ASL people out here tonight. I'm excited to see that. I've been interpreting for 22 years, specializing in legal interpreting, going on 14 years now. I used to be the certification and training coordinator here with Court Language Access Services, so these type of CEs and really working with interpreters and having this type of dialogue is really dear to my heart. I see the benefit it has for our profession, and I really do enjoy being involved and engaging in these types of conversations. I always have something to learn. Doesn't matter how long we've been out there doing it, something comes up, and it's always really good reminders on how to continue to work in the profession. Also, we have the voice of the people, as we like to call him. He is here tonight, Ed Aledo. Ed, do you want to go ahead and introduce yourself for the audience tonight?
Hi, Mel. I'm very happy to be here in a little bit different role for myself. I'm usually one of the talkers. Today I'm going to be the typer. Well, let me talk about myself first. I am about to embark on my 40th year as a sign language interpreter.
I'm getting my jaw off the ground. Hold on. Okay.
I finished my training in 1978, and I began interpreting in the fall of 1978. Not in courts. I started out in an educational setting, but eventually made my way to interpreting in the courts during the 80s. I'm not sure how long ago that was. And been working, started freelance as a freelance interpreter, contractor interpreting in the Oregon courts in the mid-90s. And then 10 years ago, almost 11 years ago now, I joined the staff at the Oregon Judicial Department. That's the state court system here in Oregon, that's what we call it. And started out as a staff interpreter, and then for 2.5 years now, I've been our interpreter analyst. And that's just a fancy name for the member of our management team who's an interpreter. So part of my job is to do things like this, do training. I also work with newer interpreters. I consult, give my opinion on policy, procedure, that kind of thing. My role tonight, though, is I'm the voice of the people. So I'm going to be the conduit through which our audience members are able to participate. So a couple of ways we can do that, and I'm looking at the emails, the slide presentation, and I see, oh, some of it's coming through. Some of those photos didn't come through, but we'll go through this technical explanation, and hopefully it will, and there it is. Okay. First thing you want to get to know is you want to get to know your control panel. The control panel, you see it on the right side of your screen. The important thing to see there is the orange button. If you click the orange button once, that control panel will disappear off the edge of your screen, except for that little orange button. You click that orange button again, and then it'll pop back. So if you're looking around for it, you can't find it, look for the orange button. The next thing we want to talk about is the ways that we can make contact, communicate with each other. We're going to do talking mostly, but you can do a couple of things. At certain points, we'll ask some questions, and you can raise your hand. We'll ask you to raise your hand. You can see the raising hand icon. It's on the control bar, a couple of spots down from where that orange arrow is. So I'm going to ask you a question now. We're going to practice raising our hands. Okay, first of all, I'm going to take everybody's hand down, and I'm going to say, how many people have ever been on a webinar before? Please raise your hand if the answer is yes. You've been on a webinar before.
Just
Okay.
any type of webinar.
Any webinar at all. Okay, and we're seeing, oh, that's easily 3/4, probably a little higher. So I'm going to take all your hands down again. I'm going to ask another question, give people another shot. How many people have been on an OJD webinar before? How many of you have been on one of these webinars before? Ooh, still a good number. Half, I would say. Something like that. Something like that. Okay, thank you. And I'm going to put your hands down. Now, the important thing to know about the hands up and hands down is that we don't respond to them. If you have a question, if you raise your hand, we're never going to answer you. We don't treat those as questions. If you do have a question or a comment that you'd like to add, go to the questions box. Now, here's the trick. It's not the chat box, but it's the question box. Make sure you're in the question box. You click the little down triangle next to the word questions, and that question box will pop up. You type in your question, you send it off, and it comes to me. And what I'll do is I'll respond to it, or I'll pass that question along to our panel. Sometimes what happens is several people have similar questions or related questions. Sometimes I'll combine those into a question or a comment and then pass that along to our panel. The other thing we'll do is sometimes we'll talk to, let's practice with the question box. I'm going to ask you a question, and you're going to answer me by typing your answer in the question box. How many times do you interpret in court in the average month? So on average, how many times do you interpret in court?
We were discussing this before we started, and unfortunately for me, with ASL for the state of Oregon, I don't interpret that often, but I sure drive a lot to get to where I interpret. So if the question was how many miles do you drive a day, I think I'd be the winner. But times in court, probably not as much as definitely some of our Spanish interpreters and Russian and so forth.
And we've got a real variety here. We've got 10 times a month. We've got 20 times a month. I think that's the highest so far. We've got once a month. So there's someone who doesn't get into court that often. Okay. So that was in 0. Ooh, not yet doing court interpreting. Okay, so we have a noob with us. Congratulations. I'm glad that you're starting out with training. It's a good way to go. And the last way that we communicate with each other is via polls. So I'm going to open our first poll.
Our getting to know you poll.
Yep. And there it is. Who has refused a job based on a known conflict? Okay, and you see your selections there. Yes, rarely. Yes, often. No, never. So we'll give everybody a chance here to respond to that. The last way, and while you're responding to that, the very last way that we might be able to get some interaction with our participants is via the phone. If there's a question or comment that I think especially lends itself to a discussion, I will unmute that participant's microphone or telephone, and we'll ask them to ask their question verbally, and we'll have a little discussion. I won't do that out of the blue. I'll definitely send you a chat to ask you if you're willing to do that. So I'm not going to surprise anybody. Okay, so I'm going to close it. And there we are. There's a result. Rarely, 67%. I think the judge may have something to say about that a little later. Yes, often, 3% of us. So pretty rare, pretty rare. I'm kind of surprised by that number. And then no, never, 30%. So 97% of us rarely or never have disclosed a potential or a conflict of interest.
Refused a job.
Or refused a job.
Or refused a job. I'm sorry, refused a job based on a conflict of interest. Interesting. Okay.
Thank you,
That's
Ed.
all I've got, Mel. Let me send it back to you.
Well, hopefully you'll be busy tonight with people typing in, because you guys, this is how we get you to be involved in this and not make it just to be about hearing us talk tonight. We really do want this to be an interactive event. Ed's here. He will be answering your questions, commenting back and forth, and then kind of culling those together and pulling them together to share with us on the air. So please keep him busy. Also, just want to do a shout out about who we have here tonight. We have registered 44 people. We have people from the state of Washington, Oregon, California, Texas, Minnesota, North Carolina, Florida as well. We have several languages. Again, this is why it's so important to keep examples language neutral, and we definitely try our best, but we have people here that speak Arabic, French, Samoan, Spanish, American Sign Language, Farsi, Armenian, Dari, Russian, Somali, Quiche, Amharic, Portuguese, Hungarian, German, Burmese, Vietnamese, Cantonese, Mandarin, Tagalog, and Akano. I think I said that right. So it just always impresses me and amazes me about how many languages get represented in the courts throughout the United States, and how many people are furthering their knowledge and their training by attending these types of CE. So welcome everybody. Hopefully we'll have a great dialogue tonight. So kind of based off of that first poll, hopefully we'll see, some of those answers might be different if we polled again in a year. So our goal tonight for this webinar is by the end of tonight's webinar, you will have a better understanding of canon number 3, impartiality and avoidance of conflict of interest of the Code of Professional Responsibility for interpreters in the Oregon courts, and its implications and limitation for court interpreters. Again, we are following our code, the Oregon Courts Code. We have noticed that many state courts are very similar, and they're based off the National Center for States Courts model code. So hopefully this will be familiar to people, but when we are talking about what we would do here in Oregon. Our objective with tonight's webinar is that we hope to accomplish the following by the end of this evening's webinar: that we will deeply explore Canon 3, impartiality and avoidance of conflict of interest, to understand what the court is really looking for with this canon. Also, to identify and work through scenarios and possible outcomes for court interpreters, so that in real life these solutions can be made more easily identified. So hopefully by the end of tonight's discussion, we will be able to have said, yes, we have reached our goals and our objectives. So I'm going to just go ahead and really just dive into canon number 3, the one that is our topic for tonight. So I'm going to go ahead and just read canon number 3 and get launched into it. I am noticing, just for people out there, we are having a little bit of a slow internet connection tonight, so I do apologize for that. As our slides are being advanced, there's a little bit of a lag. So as I read them, they will be coming up sooner rather than later, so thank you for your patience. So canon number 3, impartiality and the avoidance of conflict of interest, court or proceedings interpreter. The interpreter shall be impartial and unbiased, and shall refrain from conduct that may give an appearance of bias or conflict of interest. The interpreter shall disclose to the judge any real bias or interest in the parties or witnesses in a case, or any situation or relationship that may be perceived by the court, any of the parties, or any witnesses as a bias or interest in the parties or witnesses in a case. So, it's so hard when we start planning for these webinars. We, think about the year, think about situations that have come up, and this one kind of stood out to me, and I thought I picked it so that we can really talk about what does it mean to have a conflict of interest, what is a bias, what is the court wanting from us, and how as professionals we should be able to move forward and navigate the court. When I was looking at this one, I thought about Canon 1 speaks to our work on interpreting. Canon 1 is that we will interpret accurately and completely. So that's really talking about our work as interpreters, that we will not add or omit, but that's more about what we do. And then Canon number 2 speaks to about our representations and our qualifications, that we won't misrepresent ourselves, that we will speak to our training. But this one, Canon number 3, is the one that really makes us act as professionals. It kind of guides our conduct within the courtroom. This is the canon that gives us the ability to participate, that the court wants to hear from us, from our history, our experiences, and to kind of asks us to do a little bit more analysis, I guess I would say, on our professionalism about do we feel this is a conflict? Is there something that's arising that I need to let the court know? I don't know, Lisa, did you have any thoughts when you were preparing for this, or how do you feel about canon number 3 with conflict and impartiality?
The word that comes to mind right away is neutrality, just that neutral not looking like or giving the appearance of, or in fact doing, favoring one side over the other. And I agree. It's the whole analyzing these real or perceived potential conflicts, but doing that before, during, and post interaction. And that way you become more familiar with that process and you don't have the deer in the headlights moment, which I know all of us have had at times in the courtroom. And but the more that we think about neutrality and what that might look like to other people, I think the perceived part is one that can be the most ambiguous. Mm-hmm. We know whether we have a conflict, usually. Can I be neutral or impartial in this matter? Interpret in a neutral manner. But what do the others maybe think because of something that happened in the hallway or an interaction that I had where others may have been privy to?
Or if they heard about something after the fact and then yes, had questions about it. Mm-hmm. Judge Weber, do you have any comments on that?
As I've been reading it over and over, the words that come to mind that I've jotted down are kind of a golden rule, overarching, and general guidance, kind of as a starting point. This is what we're aspiring to make sure that we're letting the court know about, and kind of something that you might want to return to on a really regular basis, to remind yourself, this is the obligation I have to the parties, this is the obligation I have to the lawyers, this is the obligation I have to the court. I need to go through this analysis every single time I'm working on a case to make sure that I'm not appearing biased in any way.
Mm-hmm. Okay. So, oh, go ahead, Lisa.
I like that analysis to be done regularly, because I have to say that since I have been doing that, I have been more proactive and aggressive in my willingness to look at, I may not be perceived as neutral or impartial in this matter. I need to make a decision as to what to do about it.
Mm-hmm. Mm-hmm. So thank you. So again, this is the beginning of our discussion, and I want to use the title of our webinar, the 5 W's, to further our discussion. So when we look at this, it says right in there that we have to disclose. So I'm going to start in with who needs to know. So let's say that we've done our analysis, we've kind of thought this through, and we feel like, yeah, we actually have a conflict. And it could be a conflict based on what the canon clearly says, and we'll get into those, that it actually identifies for us what is a conflict versus something now that I feel is a conflict that I need to move forward and inform the court about. So if we look at it, it says right in there, we have to disclose to the judge. So right off the bat, it's telling us, yep, you have a conflict, you need to let the judge know. And then if you look in the commentary, and with this one, the commentary for canon number 3 is really where the golden nuggets are for our discussion. So if you have the canon or the code of professional responsibility with you and you have the commentary available to you, I would say go ahead and dig that out, because we're going to be referencing that a lot tonight. I've tried to pull out pieces of it here in our presentation, but there might be some other pieces in here that can help guide your understanding in our discussion as well that I wasn't able to just put right up into the presentation. But it says at the beginning, on the first read over, it says that we have to let the judge know. So Judge, why would a judge want to know that there is a conflict?
Because if the interpreter thinks there could be a conflict or knows that there's a conflict, I need to flesh that out before we can do any interpretation. It may well be that the interpreter is erring on the side of caution, is really overly wondering, kind of a little hesitant, is this a conflict? And it really isn't. Or it may be that the interpreter thinks it might be a conflict and I see it as a huge conflict, and I want to be the one, since I'm in charge of the courtroom, I'm in charge of everything that's happening in the courtroom, I want to make sure that I'm a part of the conversation to flesh it out before a decision is made, and that decision is always ultimately going to be made by me.
Okay, so when we look into the commentary, it then says later on that we have to disclose to all parties and the court. So why would it add those additional pieces, do you think? Do the attorneys and the parties actually have a say if there's a conflict? You know, would they be able to have a comment on that?
Absolutely. And very often what can happen is an interpreter can indicate something like, I have a conflict, Judge. I know this person through my church services. And the judge can look at the parties and say to the attorneys, do either of you have any concerns about this interpreter serving as the interpreter for this proceeding? Frequently, they're going to say no. We know this interpreter. We've seen him or her on a regular basis. We don't question their integrity. Let's just go ahead. Or the attorneys may say, you know what, Judge, I want to ask the interpreter some questions to delve a little bit farther into that. After the questions are answered, maybe the attorneys are fine with it. Or maybe one of the attorneys says, you know, I chatted with my client in the hallway. My client's also concerned. We'd like a new interpreter. Mm-hmm. So there are so many different options that I really need the ability to flesh out with the lawyers before I can make a decision.
Just listening to you, I'm also thinking like court in general is an adversarial system, right? And so one party shouldn't know necessarily what the other party doesn't know, and they should each have a voice. And then you're the judge, and you get to make the final decision, but they each get to at least make their argument.
100%.
Right. That's something to keep in mind. Okay. So that's the who, you know, so we've kind of fleshed that out. And then what does the judge need to know? What do we have to disclose? So Canon 3, really, like I said, there's a basic analysis that's already done for us about what needs to be disclosed to the judge. It says any real bias or interest in the parties or witnesses in a case, or any situation or relationship that may be perceived by the court, any of the parties, or any witnesses as a bias or interest in the parties or witnesses in a case. And Lisa, you kind of talked about perception. And I think perception is a little bit harder to defend or to talk about. And so I think it's just easier in some ways to go ahead, put any possibility on the record, and then that perception is already out there. Like, I don't need to worry about if something happens down the road that I'm questioned about. Do you have any thoughts about that?
Right, I agree. I think that if we have any doubt at all, that we ought to be mindful of the repercussions of remaining silent. And I think way too often we're just afraid of interrupting court, and I'm using fake quote signs there because that is not, we are an officer of the court, and we have the responsibility to say something, but we need to really think about what could happen if I remain silent. Could there be a mistrial? Could there be an appeal based on this, on my even perceived lack of neutrality? So I think that yeah, we need to, I think we more often remain silent when we ought to speak up. Mm-hmm. If we have any doubt at all, let the judge make the determination. That's why they're there. And I really appreciate Judge Weber's comment about that.
Yeah, thank you. Judge, do you have anything else you want to add?
I do. I've been a member of the bar since 1994. I was a courtroom lawyer for almost all of the years that I practiced, and I've now been a judge for 7 years. And I cannot think of a single time that I've dealt with an interpreter situation, either as a lawyer or a judge, where an interpreter brought to my attention that they believed there was a potential conflict of interest. I've had interpreters tell me, I've interpreted for this person on a previous court case or on this case before, Judge. I've had interpreters, especially more recently, tell me I've interpreted for this person in a medical situation. But I've never had anyone point anything else out, and that leads me to one of two conclusions. Either everybody's doing a superb job screening themselves out before they come as an interpreter, or people just aren't comfortable enough bringing the conflict or the potential conflict to the knowledge of the court. I even reached out to some of my colleagues in my county, and about 6 of the judges replied, and none of them had had it happen either. So as an attorney, as a judge, we're trained as legal professionals to go through that analysis at the beginning of every single case. When you are assigned a case, your first step before you do anything else is to run a full conflict check. We have to go through that process immediately. Every time someone else new gets involved in the case, you have to go through a conflict check again. So if it's brought up to me in the courtroom, if it's brought up to the lawyers, we're used to this. This is totally common. So for an interpreter to bring it to our attention, that's something that is very, very normal to us, and we're very used to going through the analysis.
You know, Judge Robert, I don't think I knew that. I don't think I knew what an in-depth analysis attorneys and judges make, and that this is something that is very familiar to you guys. It kind of feels like it gives us permission to do more of an analysis on our end. And to, like you said, we're speaking the same language then, right? Like if I come to you and say, hey, I've done my analysis, I have a potential conflict that I just need to let the court know about, that you know what I'm talking about. Like you're going to get it.
Exactly.
Yeah. Okay. Well, see, I think this is new for us as interpreters to kind of think about it from this different perspective, especially as, you know, we try to be more professional. We're working more in the courts. We have to learn from our colleagues, and you guys are our colleagues in that regard of doing that type of analysis. Ed.
Mel, just reminding our participants that I'm here waiting for their questions, comments. I also want to point out that we have an actual judge here with us today. And if you've, I don't know, anything like me, I've always had these little questions. I'm like, what's a judge think of this? I do this every day, but what does a judge think of it? Well, now's your chance to ask. So I invite people to enter their questions in the question box. Don't put it in the chat box. Put it in the question box and send it to us. Thanks, Mel.
Well, and I want to remind everyone too, and remind myself, I'm only speaking for myself whenever I give any opinions or any thoughts or any ideas about how I would want things to be done. I'm not speaking for any other judge, nor am I speaking for the Oregon Judicial Department. And we are all 200 plus individual people with individual quirks and individual ways that we run our courtroom. And I'm sure many more hundreds all over this country.
Thank you for that. So when you talked about the conflict analysis that judges and attorneys do, what are the things you guys are looking for, and what would be a hard conflict versus something that you just need to put on the record just so that that perception gets cleared up and it's out there? What are the things that you guys look for?
From an attorney point of view or from an interpreter point of view?
From an attorney. Well, I guess the interpreter. That's who we are tonight. Yeah. I'm just curious more, I guess, about what you guys have been trained to do and what you guys are looking for and what I can take from that.
Let me talk through it then kind of from a lawyer point of view. Mm-hmm. As a criminal defense attorney, I would get assigned a case. I would get the defendant's name and the list of all of the witnesses. I would then go into my list of every single person that had ever interacted with any other case that I had done before, and I would see if I had represented that defendant before, if I had represented a witness before, if I had represented a victim before, and if I had represented a victim on this defendant's case, I'm hands off. I can't touch the case at all because that's a conflict of interest. So it's that analysis that we're going through. Names may pop up like police officers on a lot of different cases. That's not a conflict of interest because they're on every single case. An example of a conflict analysis that I go through as a judge all the time is, did I represent anyone who's appearing in my courtroom? Because then I can't be the judge on their case. And my husband is a civil litigator, and so on every civil case I get, I have to call his office. I have to have his office run a conflict check so that I'm not making a decision about a case that his firm has been involved with. So see, lawyers we're doing conflict checks all the time. It's constant.
So when you talked about, like, if you had represented the victim, you would automatically be out for the defendant to defend him. That's just a clear-cut conflict of interest.
Absolutely.
And so if it's, say if it's, you've interpreted a victim for this defendant, and then so you one victim in a case, but then this defendant comes up again, different victim.
From an interpreter point of view?
Yeah. Mm-hmm.
And this is just interpretation in a court setting.
Mm-hmm.
As a judge, I'm not concerned when I have a court-certified interpreter who's interpreting on a regular basis in a court situation, because that's in the court situation. It's all on the record. And so just the fact that that interpretation has happened doesn't cause me concerns. Lisa?
So I have a question about that. But if the interpreter within themselves thinks that they may have that there may be a potential conflict or perceived conflict, you would not be resistant to that interpreter bringing that before the court?
Absolutely not. I would much rather know. I have no problem with an interpreter, the first thing out of his or her mouth saying, Judge, I want you to let you know I've interpreted for this defendant, I've interpreted for this victim, I've interpreted for this witness in other court proceedings. It's on the record. Everybody knows it. We can move on with the next step.
Appreciate that.
Got it. Okay. So these are like, again, going into those real biases, those concrete things that we're going to jump into. I think one of the softer ones, though, that isn't as clear-cut, it's not like, yes, I've interpreted before. It's this phrase in the commentary that says, any condition that interferes with the objectivity of the interpreter constitutes a conflict of interest. So I pulled up the definition of objectivity here, and that's the state or quality of being objective, not influenced by personal feelings, interpretations, or prejudice, based on facts, unbiased. So that just kind of gives us the framework of what objectivity means. But now that I'm reading this, you know, what is a clear conflict of interest? I don't know if in our training it's as defined as it is with the attorneys and judges, like bam, that's a conflict of interest, bam. We do have 5 that the code really clearly states for us, and that is we have a conflict of interest when the interpreter is a friend, associate, or relative of a party or counsel for a party involved in the proceedings. So if I'm a friend with anybody in the court case, I'm an associate, I know the counsel, I'm involved somehow in the proceedings in another way. So that's like you're saying, I'm out, hands off, okay? When the interpreter has served in an investigative capacity in the case at issue for any party involved in the case. So for me, investigative comes to mind as the police work, maybe grand jury. Is grand jury considered investigative? Maybe not. So like the police investigation of the detectives, that type of stuff. So outside of court, still kind of building the case. The interpreter has previously been retained by a law enforcement agency to assist in the preparation of the criminal case at issue. So I guess that answered that one for me. And then this one, the interpreter or the interpreter's spouse or child has a financial interest in the subject matter. Well, Ed.
This is going back a little bit. Of course, when you type your comments to me, they're always a little bit lagging as what we're talking about right now. One of our participants asks, or he says, I do translations and transcriptions of audio in criminal cases under contract with the DA. If the defendant in a, say, a pretrial hearing needs my services as a court-certified interpreter for that court appearance, since I'm a possible witness, presumably because he did translation, transcription, should I go to that hearing, or are there other options?
I think that depends on the state that you're working in. Do you have something as wonderful as court language access services that you can point that out to class and ask that that information be forwarded to the judge and the judge can make a decision? In that hypothetical situation, if I got an email from class saying this is what the interpreter is indicating, I would forward that to the lawyers. I would say, does either of you object to the attorney, to the interpreter working on this case? If one of them objects, then we would use another interpreter. I think it would depend from a judicial point of view what language we were dealing with, how many interpreters were out there, etc.
And he goes on to explain it's, I think it's, I'm interpreting this correctly, what this is, it's a short pre-trial matter, and he just showed up in the courtroom and recognized the name. Let's say it's first appearance, he's being arraigned. So the interpreter didn't know ahead of time, so he showed up in the courtroom, sees the name, oh my gosh, I did translations of wiretaps on this guy.
Because it could be an arraignment docket, right? So you don't know until you get there because you're covering the docket and then you're providing, let's just say it's Spanish, you wouldn't know until you got there. You don't get the names ahead of time.
And the specific question is, should he just recuse himself at that point, or should he make a disclosure and let the parties and the court make a decision?
That's a difficult question, and it's difficult because I'm going through the legal analysis of whether or not the wiretaps are even known to the defense, whether those are wiretaps that are involved in this case or a different ongoing investigation. So what I would do is I would take that interpreter back to their first role, which was as an interpreter for the district attorney's office, and I would have them kind of divorce themselves from the court interpreting role for a moment, have a conversation with the district attorney that's there first of all, find out, do you all consider me your private table interpreter essentially for this purpose? I'm here for this court appearance. If that district attorney freaks out and says, you can't talk about the fact that there's wiretaps, this defendant doesn't know that, I don't want that to be on the record, then you're in a very different place. So that adds another level of complexity, and that's because they've already been hired by one side for a specific purpose.
As we're going through this analysis, Judge Weber, it also comes to mind, okay, this is an arraignment. The person probably doesn't have an attorney yet, right? Because unless he got a court-appointed attorney, maybe somebody standing in while they're doing their arraignment, and then you have a district attorney that if you approach and talk to them, right. First of all, let's be clear, the district attorney doing arraignments isn't the one that ordered the wiretappings to be translated. Right. They don't know anything probably, right?
Right.
Does that, having somebody be represented and not represented, and like the interpreter, I guess we always think about or get warned about don't have ex parte communications. I just used a legal term, I'm not even sure if I used it correctly, but you know, communication with one side and not the other. You know, we don't want that to happen. Does that have any bearing?
It does, and we're getting into very icky, murky waters.
Right.
I think what I would do with that interpreter is I would take them back a step farther when they were actually working with the district attorney's office and doing the translation. I would have that interpreter say to the district attorney's office, what do you want me to do procedurally if I'm called as an interpreter on a court appearance? Do you want me to indicate that at the court? The district attorney's office might say that's not a problem. This is, everybody knows about this wiretap, etc. The district attorney's office could though say, you're our interpreter. We don't want you to be in the courtroom. Gotcha. If you showed up in the courtroom though, and if you realized you knew the name, and if you realized that you had interpreted the wiretap, I personally would be a little, I would be very worried as the interpreter. I understand him or her being uncomfortable in that situation. I would probably call class. I would probably have a conversation with the agency that sent me there and kind of put the brakes on it a little bit, primarily because you could be opening a can of worms if you start talking about a wiretap that isn't public knowledge that's part of an ongoing investigation.
I think when we go talk about the how and we get into our scenarios and do some role playing, there's a really clear way to say, Your Honor, I've had, you know, I have worked on this case previously, and just less Correct. Is more, whoop, you know, and then kind of give the eyes like, and I need to not be here, type right. You know what I mean?
Yes.
And get out of that pretty quickly without disclosing any of that.
I think you're right. I think I was making it more complicated than it needed to be.
No, but I don't think we think about that because you're right. My gut instinct is to go, oh my gosh, people, I need to get out of here. You know, and I'd be very anxious. I wouldn't say it.
Would it be okay if the interpreter actually said, even kept it even more general and just said, Your Honor, the interpreter has a conflict of interest and is unable to
and I cannot
in the matter.
Yeah, absolutely. Mm-hmm. That sends me a message clearly. If you say you have a conflict of interest and you can't be the interpreter on the matter, that's it, we're done. We'll reset the arraignment.
And you don't even say why.
And then you don't even say why.
Okay. I've just got some feedback from Michelle that we're having trouble hearing Lisa as she's talking. So I am going to go ahead and see if I can help with that. Nope. Okay. So let's keep going. So thank you for this discussion. It's very rich. So we've got really clear about when we need to do that. So the interpreter has been involved in the choice of counsel or law firm. I don't quite understand that one, but that's very clear conflict as well. And then when any condition arises and causes that interference or objectivity of the interpreter. So again, just as we're coming to a close with part of these like bigger discussion pieces here, the code very clearly. Sorry, you guys, we're just having some audio problems right here.
Testing. Testing.
Okay. Okay, so when we talk about any condition that arises that causes interference with our objectivity, I think what comes to mind that I just really want to talk about and put out there is that we're human, we're interpreters. You know, we're very clear on what's happening. Sorry, we're working out our, there we go. Okay, so those conditions that could arise that might make me feel like I'm no longer neutral. It's happened. I have recently been divorced, and when I went to do my first family law counter and somebody else was getting a divorce, I didn't even think about it. When I took the job, I'm a professional, and then lo and behold, oh, I had a response to that. The more touchy ones, I think, are when you're doing a trial. And, you know, you've read these articles, you're interpreting, and it's a sex abuse case, and it's about children, and you have a child of the same age, and you become emotional. Or you're a victim, and it's the same type of charges that you're a victim of, and that causes you to be so, I don't know, biased at that point, because then your own experience is bleeding over. Those are the types of things that I think are a little bit harder. I mean, we have the code that's like, boom, if you are going to get money out of the decision of this case, you're out. If you've done the investigative work, you're out. But this kind of nebulous, emotional, touchy-feely stuff, I think, is harder to kind of flesh out and to have those conversations about. But it's in the code. We have to. If we're so distracted or we're so, you know, no longer neutral, the court wants to hear about it, is what this says to me, and that there's a way to do that, and that is to, you know, let the judge know that they have a matter for the court. Or, I don't know, Judge Weber, how would the interpreter just let you know what's going on for them if it's impeding their ability to interpret at this point?
I think, first of all, whatever it is that's an impeding your ability to interpret, you need to let the court know. You don't always have to let the court know exactly what it is. You don't need to let the court know, I've just been through a divorce, this is a divorce case, I'm far too emotional, it's affecting my ability to neutrally and impartially interpret. I don't need to know all that information, but I definitely need to know, Judge, I can't continue interpreting on this case. I need to let the court know that I'm going to need someone else to take over. Maybe we need to switch out a little bit more quickly. Maybe I need a break. Maybe I just need to remove myself from this whole situation. Mm-hmm. What I need to have happen, though, in the courtroom is for it to happen in a controlled manner, especially in front of a jury, because we don't want to be doing something like a child sex abuse case and be on day 3 of a trial with a jury and have an interpreter who, due to their own experiences or simply their own feelings about the kind of a case, have their emotions affect that, and then have the jury know about it. So the magic words in Oregon, and I think the magic words in most states, are, Judge, I have a matter for the court. If you're in a jury trial and if anybody says, Judge, I have a matter for the court, that is our magic words to say, we need to talk about something and we don't want the jury to hear about it. So if you say, I have a matter for the court with a jury, that jury will be taken out and you can have a conversation with the judge. If you don't want to have the conversation on the record in the courtroom with the judge, you could ask the judge to go into chambers and have a conversation in chambers. In that situation, you'd probably have the judge bring in the attorneys. So you need to understand that if you're going to do that, the attorneys are going to be there as well. But sharing it, letting the judge know that you're affected, that you can't continue to successfully interpret, is really important, because I have to make sure that the interpretation is quality and the interpreters are doing the best they can. And if something's affecting you that's not helping you to do the best you can, let's get someone else on the case. Mm-hmm. And I want to emphasize too, it's not a bad thing. There are judges I know that don't do family law cases where child sex abuse is involved. There are judges that I know of that don't do animal abuse cases. There are attorneys that don't do that kind of work. And that's because those people know they can't do their best job on those kind of matters.
Mm-hmm. And I'm saying, Ed is saying that we have some comments from the participants, so let's go ahead and bring some of that discussion in.
Actually, I think this is a question for you, Judge. Do judges sometimes ignore the interpreter's disclosure of potential or actual conflict of interest in order to just make the hearing happen on that day because everyone is there already?
It's a really good question. And a judge may decide that for the purposes of that hearing on that date, the conflict is not so essential that the interpreter needs to be removed. For example, if it's an arraignment on a criminal matter and we know it's only going to take a few moments, a judge may say, we're just going to go ahead with the interpretation. We need to do the arraignment today. This is a brief procedural matter. Let's just get this taken care of. We'll make sure, Madam Interpreter, that you're not here next time. I don't think it's the judge ignoring the conflict. I think it's the judge doing a balancing act. How serious is the conflict? How serious is the court appearance? how short is the court appearance? It's kind of a gradation of importance on that. Would a judge make an interpreter do a full contested hearing or a full jury trial where they've indicated there's a conflict of interest? I cannot envision that kind of a situation ever occurring unless we have a language that is so rare that we only have a very few number of interpreters, and we're just going to have to do the best that we can. But no, I don't think a judge would ignore it, but I think a judge might go through a balancing and keep the interpreter for that appearance.
Like there's an analysis that the judge is going. I've often thought too, when I've had a conflict or I've seen something like that happen, is there are legal timelines.
Yes.
Right? That is going to kind of trump.
Correct.
Right? You want to talk about that a little bit?
We have very specific deadlines, especially on criminal cases, about times within which certain things have to happen, arraignments, probation violations, trials have to be get scheduled, etc. And the due process rights of the defendant are important, and the interpretation is important, and as judges we have to figure all of those things together. If I, in my courtroom, understanding interpretation, had a situation where I was going to kind of shove us through with an interpreter that had a conflict, I would make sure that we were doing the interpretation consecutively. I would make sure that the voices were loud and on the record so that if there were a challenge to the interpretation later, we could have a language expert take a look at what was said.
Nice. Ed, some more comments from the participants?
We have a couple of interpreters asking basically the same question. Their question is, so I've interpreted for this attorney and this client, defendant, in the attorney's office, their consultation. And now I'm asked to interpret for this defendant in a hearing before the court. Do I have a conflict that I need to disclose?
I wouldn't call that a conflict. I wouldn't call it a conflict, but I would call it an issue that you wanted to bring to the judge's attention, a potential conflict of interest. And again, the judge will make a decision. Is this a situation where you met with a defendant, went through a DUII police report, and discussed the diversion paperwork? I'm probably going to keep you as the interpreter in the courtroom. Is this a situation where we have an aggravated murder case and you've been working actively with the defense team and you've traveled out of the country and interviewed witnesses and spent countless hours with the defendant? Then I'm not going to have you be the interpreter in the courtroom. I know it happens a lot, and the attorneys are usually the ones that bring it to the court's attention, but again, it's really a gradation. It doesn't mean you have a conflict, but the more serious the case, the more a judge could see it as a conflict.
But would you agree that that is something that the interpreter would need to bring to the court's attention?
I would like to know that, and I'm sure the district attorney's office would like to know that too. It's an open court. Everyone has due process. We need to have things like that be out and open. And I'm trying to think right now as to when that's come up, and normally it's come up with the attorney saying, I've met with my client using this interpreter before, they've filled out the paperwork, etc.
When I look at Canon 3 here, it says when these are actual conflicts, it says if the interpreter has served in an investigative capacity in the case at issue for the part or any party involved in the case. So would that's not investigative, or it is if I've interpreted for counsel?
I don't think that's investigative.
I don't think it is. Okay. And then it says if the interpreter has previously been retained by a law enforcement agency to assist in the preparation of a criminal case at issue. So
that would be your gentleman who did the wiretap analysis.
Okay, so that's not the defense attorney, and that's not the district attorney. So you're right. In going on what the code has already said are actual conflicts, having interpreted for defense is not one of them. I think a lot of people feel like that is a conflict because I'm helping prepare the defense. I'm part of that, like you said, the table interpreter. They might be interpreting, and they might sometimes in your role when you're helping work with the defense in the attorney's offices, you might share some of your information, like you know what I mean? Like you're interpreting, but they might ask a question, and you know.
I think that this could be seen a number of ways, and I could see judges that would interpret a defense attorney using an interpreter for an office meeting as actually being in an investigative capacity. Okay. I can see that as an extreme analysis. I see an investigative capacity in the case at issue, more interviewing of witnesses, more going to locations. But why not err on the side of caution? Mm-hmm. First words out of your mouth are one sentence. Judge, I want the court to know that I have provided interpretation services for this attorney and this defendant in their office appointments. That was about 20 words. You told the judge. If the judge has a problem with it, you're off. It's the judge's decision.
And then the other counsel has the right to comment as well.
Right, absolutely.
Okay. Okay, so this kind of clearly talks about like when we have to bring stuff to the court's attention. And what I'm hearing from Judge Weber is bring it to the court's attention. Let the judge decide. It's not a problem that judges and attorneys do this type of analysis all the time about what is a conflict of interest, and that they'll be able to help navigate what to do and make that decision.
I would kind of follow up a little bit. If you've been the interpreter in the defense attorney's office with the defendant, just turn down the assignment when you're called to go and do the plea. Just say, I can't do that, and cut off the problem even before it becomes a problem.
I think, yeah, good advice. Thank you. Okay, so how and where do we disclose? This is the next W in our 5 Ws. Is that right? So again, Judge Weber, when do you want to hear from the interpreter?
As soon as I know that there's going to be a problem, immediately.
So that would be talking either like getting, Lisa, have you had to do a disclosure? Have you done that?
Yes, I have. And what I have done, what I try to do before I even get into the courtroom, I've called class and I've gotten some feedback, some advice, but it's still incumbent upon the interpreter to make that decision of whether there is a conflict of interest or perceived. And once that analysis is done and you still feel that you can go on and interpret in a neutral manner, then I would prefer to go in earlier, get the clerk of the court, let them know that I have something I need to put on the record, and it has to do with a potential conflict of interest. They can give that to the judge. The judge can make a decision as to whether they want more information, but then you get into the courtroom and you're not stuck with, oh no, there's no time, it's going too quickly. And also the judge can come in and keep things moving as well. I understand, Madam Interpreter, that you have a disclosure for the record. What is that? We get it on the record. It's already kind of been processed and analyzed. And it gives the judge that opportunity where they're not having to make a last-minute decision on the bench, which is probably not, just a surprise. Oh, I had no idea that this was going to come up. Okay, let me think about this. And I think it just makes things run more smoothly. There have been times you can't get to the court clerk and you can't get that done ahead of time, but I try to keep it as succinct as possible. One sentence, get it all in there in one sentence, let them know, Your Honor, the interpreter has worked with this LEP person, whatever they happen to be, in another setting, but it will not affect the interpreter's ability to render a neutral interpretation in the matter before the court today.
And that is not a disruptive sentence to be saying in the courtroom right before you're interpreting. That is not what that does is that shows me that you are being fully honest with the court, that you have a huge level of integrity, that you're going to let me know even if it's probably not a problem, that there might be a problem, and then I'm making the decision. I would love to hear that more in the courtroom.
So what I'm hearing, Judge Weber, is like the interpreter then would approach the court clerk.
Yes.
Let the court clerk then communicate to the judge that the interpreter has a conflict of interest that they want to inform the court about. Do you want to know what it is before we go on the record?
I don't really need to know that, and I would phrase it as a potential conflict of interest. If it's a clear conflict of interest, one of those clear issues that you need to absolutely remove yourself, you've already removed yourself. This is one of those more gray areas. I interpreted for the defendant in his office meetings with the attorney. I was involved in interpreting at grand jury. I interpreted a medical appointment where we discussed some serious medical conditions and the individual was very emotional, those kind of things.
Okay, and so that helps. So Judge Weber, why is this so important? Why do you want to hear from the interpreter about these conflicts? Why does the court want to know?
Because we cannot have any bias or anything even close to that and we can't have a perception of bias. And I think we're getting into the gray area that's not the clear conflicts, and it's more of those amorphous. I know the person from my church, and I know the person because our children go to school together, and we don't want an interpreter to walk out of a courtroom and be hugged by the child of a participant that they didn't expect would be in the hallway, because then everybody else leaving the courtroom sees that emotion, and even though the interpreter knows they've done a really fabulous job and they've been impartial, it's that impartiality and or lack of impartiality outside of the courtroom as well as in the courtroom.
Is there any legal ramifications of if an interpreter did interpret and they did actually have a conflict?
Absolutely. You could very well have a complaint that if in fact the interpretation was faulty because of the conflict, you could have a case overturned. You could, I don't know if you all have a governing body that could sanction you. Attorneys get sanctioned for that kind of conflict of interest and not disclosing that kind of conflict of interest, but you could very well have a conviction overturned.
Okay.
It's not a stretch of the imagination.
Okay, so there are legal ramifications. Ed?
And one of our participants is saying that there's a possibility of an appeal being an issue for appeal.
Yes, that's exactly what I mean. Is a case where an interpreter issue, the lack of impartiality is part of the record. The attorney then appeals the case up to our Court of Appeals or Supreme Court. They say the interpreter wasn't impartial, and it comes back. Mm-hmm. It's also a violation of federal law, and we need to be doing the right thing.
And what about a mistrial in the middle of a long trial, and then all of a sudden now you have a mistrial?
Mm-hmm. Absolutely.
Want that. Okay, so we're going to next go on to the how. How do we do this? How do we work with this canon? And the how is actually going to be our scenarios. So I'm going to give a quick break right now and before we launch into those scenarios. So this is the time, everybody out there, that you can stand up, stretch, go to the bathroom, get a drink of water. We have some announcements, and we'll be just jumping right into our scenarios, which are the hot topics and where we get into some lively discussion. So just FYI, we have a Spanish-specific CE with Holly Mickelson. We are so excited to have her back here in Oregon. We just love it when she comes and presents with us. She'll be here October 14th. And she's going to be in Salem. There's the fees. Michelle is your contact on that. There's a place to register on our website as well. That's going to be closing pretty shortly, probably soon, so you definitely want to get in and register sooner rather than later on expert witness testimony and site translation, which I'd say are our hardest areas that we work in. Then next we have Court Language Access Services here in Oregon. We're doing orientation to interpreting in the Oregon court. So if you are interested in interpreting, if you, like I think Ed said with our poll, we have some newbies out there. If you're here in Oregon and you want to learn more about what it means to be an interpreter in the Oregon courts, this would be a great place for you to come in, have that discussion, and really get to kind of dive into what legal interpreting is all about. Next, I think, yeah, we have one more training coming up. This one's a little bit definitely specific to Oregon, remote interpreting in Oregon. So that remote interpreting over telephone, over video, we are changing how we do that here in Oregon, and we are bringing in some new technology. And so this training is really to get people ahead of the 8 ball to learn about this technology and what to expect when providing remote interpreting in Oregon. So if you do work for us doing remote interpreting, this would be definitely beneficial for you, and it's going to get you prepared more so than other people who don't attend. So please sign up for that. And again, Michelle's your contact with court interpreting programs on how to do that and to get you signed up for that one. Okay, so we're getting ready to go. We've made it through the first half of the webinar. We're ready to move on to the second half. And again, this is where we start talking about how to apply this canon. So, Lisa, do you want to start and read scenario number 1 for us?
Okay. I went to interpret in criminal court. The LEP defendant looked familiar. While establishing communication, I asked if we had worked together before. She told me she was my babysitter's neighbor and that we had crossed paths when I picked up my children. Do I disclose?
Right. So again, Judge Weber, you talked about at one point different, oh yeah, let's go ahead and launch the poll for this one first. Thank you. And while you guys are doing that, we'll go ahead and continue to talk about this. Judge Weber, you talked a little bit about the levels that you want it to bring to the court's attention. Is this something like maybe the neighbor of my babysitter, but she recognizes me? Is this something that I need to go ahead and really?
This is about as far away from the need to let the court know about a possible conflict as I could imagine, just with the facts that I'm looking at. Just crossing paths as you're dropping off at your babysitter's and it's the neighbor doesn't seem like you've interacted very much. If we added, though, a number of different facts, the more facts that we added, the more likely I would say that it would be that you'd need to let the court know. Did you chat every day when you dropped off your children? Do your children go to the same babysitter as well? Do your children hang out together? Do your children play together? How long has the neighbor lived next door to the babysitter? Did they just recently move in? Do the children all go to the same school? I think you really have to look at it and analyze, and based just on these facts, I think you're probably safe.
Okay. So let's go ahead and close our poll and see what is being set out there. Oops. Okay. So after our discussion, we have 69% of people say, yes, I do need to disclose. We have 15% that say, no, there is no conflict. And another 15% that say, ask the LEP dependent if she's okay with me interpreting. So I'm kind of picturing this, you know, in perfect scenario, at all times I have the ability to establish communication before I start interpreting. So at this point, I've gone up to my potential client, the LEP individual, and I you know, you look familiar. So I'm using kind of a formal vernacular when I'm talking to her. And if she, during that time, it's off the record, and she says, oh, I know you, and she's very familiar with me, I'm wondering if that would change it, what I would do. Because she's like, oh yeah, you, like she's that perception piece, right? Like she's being, oh, I know you, you are so-and-so. And at that point, I think my antenna would go up, right?
And that's exactly the additional facts I was talking about. The more information you're giving me, the more you should disclose. And I'm actually excited that that many interpreters thought they needed to disclose that. That's awesome. Because I don't think that many would have answered that way at the beginning of this webinar. Good job, you guys.
We've done it. We can stop now. No, I'm just kidding.
And along with that, we have some comments. I'm going to just read one of them. They're similar. I would mention it. The LEP may think that I have a conflict or may choose not to have me as an interpreter, but I would mention it.
I think that's wonderful.
And then if we at least create the space, because as an officer of the court, I'm the one, you know, if I want it or not, I have the position that I can bring it to the court's attention a lot easier than a limited English proficient individual, asking them to, you know, if they do or do not have an attorney, I don't know from this little piece here, to bring something forward would be, you know, a stretch. But I do, as an officer of the court, I can at least create the space and the opportunity to have that discussion in front of a judge who can then talk to the person and help make that decision.
I agree 100%.
Yeah. And again, if they had an attorney, I guess we would just then say, you know, through the attorney, they would bring that forward to the court's attention. Okay. Okay, let's go ahead and move on to number 2.
Scenario number 2. I was interpreting a hearing by telephone. While interpreting introductions, one of the names of the parties sounds familiar, but I am not certain. Do I disclose?
Okay. Let's go ahead and launch that poll. So again, I think this is that gradation that we talked about. So this is a telephonic interpretation, right? So I'm on the phone. I can't see anybody. There's a potential name of somebody that is being talked about related to the case.
Yes, now, I actually recently had a very similar situation come up, and I was given an assignment by class. I accepted it not knowing the name first. Then when I got the confirmation, I have the name on the confirmation, and I look at it and I thought, it sounds vaguely familiar. Now I did my pre-analysis and I thought, but it's not a name that I know personally. It's probably a prior professional contact of some sort, and I wasn't even sure it was court. And so I didn't have any conflict of interest myself. When I arrived at court, I walked in the courtroom and I recognized the face. Now, I probably wouldn't have known their name had it not been on my confirmation. And when I saw the face, I thought, oh yeah, I think it was court before sometime in the past. And I did not disclose, I did not make any mention of it in the courtroom. However, it was also a case where it was a very short matter, and I knew that all the parties were kind of already had been talking, agreements had been made. It was kind of a plea, we're just going, you know, it was going to be a 5-minute thing, and I kind of knew what was going to happen in the courtroom, and I knew there wasn't going to be any problem with my being able to interpret that. But I had to do all that pre-analysis. Then when I arrived to the courtroom, I had to think about more. Okay, I do recognize the face, but I did not make a disclosure on the record in that situation. But I think it had to do with the gradation of it, again, as Judge Weber has been mentioning.
Okay, let's go ahead and close the poll and see where people are on this time. Okay, we're doing our job here, Judge Weber. Okay.
Can I add something? I would add, this is not going to be at all strange for you to inquire about a name, because we do this all the time with jury selection. Whenever we're doing jury selection, the parties announce the names of their potential witnesses, and a lot of times jurors will raise their hand and say, is that Joe Smith that works for Providence Hospital, or is that Billy Bob that works for the Clackamas County Sheriff's Office? So asking that kind of question is very common. No one's going to hesitate, and that's going to be time well spent.
Good. I hear. See,
One of our participants comments, the disclosure avoids the fact that the person might mention that he or she knows the interpreter, and then the perception is that I, the interpreter, should have disclosed it and I was hiding something.
So,
Interesting.
So you're saying, like, if I don't say anything as the interpreter, but the witness does, and brings up the fact that they know the interpreter, right? It's a good point.
And you're the officer of the court. The witness is not. So let me know.
So I think when this, what happens is we get a pool of all these different scenarios where people write in, and the reason this one stuck out to me was doing video interpreting or remote interpreting on the phone. We do that not as often, but for short matters. Our best policies dictate, if it's something that's non-evidentiary, there's no witnesses involved, it's a short matter, scheduling new dates, that's best practices. Okay, so then you bring in also, though, we're a big state, and oftentimes if it's a rare language that somebody wants to do it telephonically because we can't get them here in person. So there's different gradations, I guess, about when we do remote interpreting. And it's not easy when the court starts going to be the voice on the phone, because nobody actually hears us usually in these matters, because we're not providing interpretation, like we're not voice interpreting for the record. We're not producing an interpretation for the record usually, because it's such a short matter, that we become more obtrusive. So I think that balancing act, like Lisa was saying about what I've done to my analysis pieces, like, the name might be familiar, but I don't know. I don't think it rises to the level. But after tonight's discussion, I might look at that differently. You know what I mean? But so we have multiple canons vying too, because we're told not to be obtrusive, but we want, you know what I mean? So there's all these elements that go through my analysis as well.
I want to clarify something that's really important. You just said I don't want to be intrusive. Letting the court know about a conflict of interest is not obtrusive. That is your ethical requirement. You are not being intrusive if you tell me that there may be an impediment to you being able to interpret. So those two things need to be totally separate.
Good to know. That's permission.
Yeah, the example that I used for the recent case that I had, though, that was a prior court interpretation for something that probably wouldn't rise to the level of needing some kind of disclosure.
I really see your prior court interpretation as very different from your prior anything else. I really do. Unless, I mean, again, gradations. If you did a 5-day family law custody battle where the defendant and the victim were the two parties on that case, and now you're here to testify on their criminal case, you should probably let the court know about that. I'm going to tell you right now, you need to let the court know about that because you got very involved in a 4-day trial. So
makes sense. Okay, so we've talked about gradation. So let's just quickly run through some different examples that we have that will kind of test that if I need to disclose or not. And in this one, it's a little bit different. This is a hand raise. So if you think you should disclose, we want you to raise your hand for this one. Lisa, do you want to go ahead and read these?
I interpreted a year ago for a person for a medical procedure. Do I have to disclose this when I interpret for them in court?
So raise your hand if you feel the answer is yes. And then Ed, do you want to read those for us, or how many we have there?
They're still coming in. We're at about 50, I would say 50% here. Oh no, it's going a little over, so maybe 60%, maybe 70%.
6%. Okay. So the reason I like this one was it was a year ago. What type of medical procedure? And they're both professional interpreting. So for me, as a community interpreter, and you know, I interpret in court, and I interpret in medical situations all the time, and everything in between. But I keep it professional. I feel like I'm able to do that. Judge Weber, what do you think?
I think there's a big difference. Again, the gradations. Did you interpret for a mole removal, or did you interpret for a serious medical procedure where they were hospitalized for 2 weeks and you were their primary conduit to the medical professional? I wouldn't personally have a problem if an interpreter didn't tell me about my scenario number 1. I would have a big problem if my interpreter didn't tell me about scenario number 2.
I have a couple of comments on this. First, one participant says, I wouldn't give details, but I would definitely mention it. That's one comment. Second comment is, yes, I'd mention it if it's a personal injury case.
Absolutely. I hadn't even thought about a PI case.
Mm-hmm.
And I don't think you're ever going to have a judge who thinks negatively if you say, Judge, I want to let the court know that I've interpreted previously for this individual in a medical procedure. We all have medical procedures. You're not sharing anything, I don't think, that violates HIPAA. We all go to the doctor. We all get medical things taken care of. And then the judge can make a decision about whether it needs to go further.
Mm-hmm. Or you could even say, not even say medical, you could just say, I've interpreted professionally in a community setting for this individual. You know, if it was a personal injury case, right? It's just, I hadn't even thought about that scenario. That's a good one.
You could say a different venue.
Mm-hmm.
I'd love that. Either way of saying that, either one.
Okay. Let's go on to number 2. We have a different example here.
Okay.
And can I say one more thing? If a judge says to you on the record, can you tell me more about what that procedure was or what that situation was? If it was a medical procedure, I would say, Judge, I have a matter for the court. Or Judge, I think we should discuss that in chambers because then you're protecting that person.
Mm-hmm.
So
Nice.
don't start discussing their medical procedures on the record, please.
This mole.
Okay. I interpreted a weekly for an LEP person's court-ordered anger management classes. Do I have to disclose this the next time I interpret for them in court?
Let's do another hand raise there if you think yes. I do have to interpret that. And Judge Weber is doing 2 hands and up in the air and all the fingers. Do you want to just comment why real quickly?
Anger management classes, you're getting so involved in someone that's like a psychological appointment. You're getting very involved in that person's treatment. That's just, that to me is about as clear of a scenario that we've had in the murky area. Just don't.
Mm-hmm.
And 80% of our attendees, of our participants would agree. They about 80%, 85% raise their hand.
Good job, guys. Thank you for your participation in the questions, too. It's really fascinating as one of the speakers to hear what your thoughts are. I like that.
Lisa, do you want to go ahead with our last example here on this one?
I went to school with an LEP person 20 years ago. Do I have to disclose this when I interpret for them in court today?
Judge Weber, you had a funny comment on this one when we were practicing this. I think you said, well, it depends if I dated them in high school. Or did I see them? They were on the other side.
Was I a senior? They were a freshman. You know, did I date them? Were we in all of our classes together? Or did you go to a school where the student body's 3,000 students? I think it's a gradation again.
Again, and I think this rises to when the canon says a condition that impedes our neutrality, our ability to be unbiased. Because it is the gradation. That is the condition. Like, okay, it's now something is there. I'm noticing it. I feel it. It's come to my attention. By the time it's come to my attention, I'm even having to ask this. At some point, I feel like that's kind of part of my analysis that I have to take.
And I would say maybe 30, 35%, maybe more now, maybe 40% are saying yes, that they would disclose something like this.
Mm-hmm.
And I think, again, it's best to err on the side of caution. If you want to throw, they may, when they have read that, thrown in a few additional facts. Maybe they threw in 3 classes. Maybe they threw in they were the same year. So it doesn't hurt, again, right when you start your interpreting or through the court clerk, Judge, I'd like to let the court know this is a potential conflict of interest. We attended the same high school together. Then the judge can ask the questions.
Right, because what if the person wants to give you a hug at the end because I haven't seen you in 20 years, right? And then
Or what if the person dislikes you and wants to spit on you as you're walking away? You never know.
That's
Gave them swirlies when you
right, something like that. Right, so it's that perception, though, that we have to be careful of. Okay, let's go ahead and move on to scenario number 3. Okay, so here we go. Members of the same congregation. I was hired to interpret a contested restraining order. Upon meeting the LEP party and her attorney, the LEP reported to her attorney in front of me that she did not feel comfortable with me in acting as her interpreter because my spouse and the LEP person's family attend the same church. Okay, what do I do? Let's go ahead and launch that poll. Lisa, yeah.
So I really liked this one because in the beginning I thought, oh, okay, this is a privileged situation. I'm with the attorney, so everything that is said there is privileged information. So therefore, do I have this piece of information? Technically. But I did appreciate that when we were discussing this, that's why I love analysis, is because we looked at that last paragraph in the commentary section of Canon 3. And it said, should the interpreter become aware that a preceding participant views the interpreter as biased? So then it made me rethink that. And I thought, oh, wait a minute, it is incumbent upon me and not the attorney to bring that up to the court. And I really liked a discussion that we had before about Ed had mentioned that while you're in the moment, it would be a good idea to let the attorney know this is something I need to disclose to the court or needs to be disclosed to the court. You can do it or I can do it, but I'm letting you know it will be done.
Exactly. Exactly.
Let's go ahead and close the poll real quick and see what they say. Okay, so, okay, disclose to the court the LEP party is uncomfortable with me. 79%, that's pretty awesome. And then let her attorney report the concern. So, Lisa, kind of to what you were just talking about, 21% said they let the attorney handle it. Yeah.
Well, one of the things I thought about privilege was, how do I address this in a manner that is not breaking that and yet bringing the matter to the court? And so one of the things that I thought about as we've been discussing this is that you can make it a very passive sentence. You don't have to say where you heard it. You could say something like, Your Honor, it has been brought to the interpreter's attention that this.
Absolutely. Absolutely. And I think that between all of the responses, everybody was right. Either way, because your example is perfect. Have the attorney, either the attorney is going to tell the court or you're going to tell the court, because the attorney doesn't want their client to be with someone that they're not comfortable with either. I love that nobody voted do nothing.
Ed, go ahead.
And another comment from our participants. I usually disclose and give the judge a heads up about my perception. For example, quote, I do not feel that it will affect my way of interpreting or create conflicts.
Superb.
Because Judge Weber, if this is removed enough, so it's not that I attend the LEP person's church, it's that my spouse does. So I don't actually have a relationship personally with this person, but because of maybe last names or they've seen me picking up my husband, they know that there is some type of relationship there. If it was one of those matters, you had a deadline, things were going, would you say, thank you? You know, so one attorney is saying we have a concern. Would the other attorney or you say, you know, noted, and this is so far away that we're just still going to proceed?
Not in this factual situation, because this is the limited English proficient person who's not comfortable. This is that person thinking that they're not going to be comfortable with you as the interpreter, and I would be worried then that that person might not trust any of the interpretations. So in this kind of a situation, I would say let's reset this, or let's get a telephonic interpreter, or let's do something else.
Would that change based on whether it was a quick arraignment or a trial?
Probably not, because it's the limited English person that's not comfortable with it. It's not you saying, I think I have a conflict, I'm concerned, I just want to let you know, Judge. This is that person saying, I don't want her, I don't want him. And that's so extreme that I would probably remove someone. Now, granted, one of my colleagues could not make the same decision, but that's what I would do. I would also mention that an interpreter should never take something like this personally.
Right.
I think that you probably would go to that emotion first in a, I don't know you person, I can interpret for you, I'm a qualified professional, I'm sent here by the court. There are psychological things going on with people that come to court that have nothing to do with us. And if you had that happen, just smile, let it roll off your back, and move on to the next case.
And we have an example of that. Sometimes the LEP person wishes to say something that, I'm paraphrasing here, that is different from what the court interpreter might know to be true, and wants to say something, be able to say something to the judge without that court interpreter's prior knowledge being even involved.
So you're saying if the, like, for example, if the interpreter interpreted in the attorney's office and knows the full story, and then wants a different interpreter in court because, let's be clear, everybody has a right to lie, that they're worried that the bleed over would happen?
I think that's what this is implying, that the defendant is going to say something that they know that the interpreter is likely to understand to be not true or not as true.
Mm-hmm. Interesting. Well, I mean, I can also take this in a different vein where in some of our smaller populations of refugees or more small groups of populations that we have here that are really culturally rich that may not be known to the wider public, if they're making a cultural comment that the interpreter knows that's not true, you know, that could happen that way as well, like even not like actual information, but or something like that. I have seen this actually come up with some of our smaller populations where somebody goes to the same church, same synagogue, same temple, and they really are very hesitant about having any type of connection brought, you know, because court is so private and they're so embarrassed, and it's for whatever it is, we've had to bring in people from other states just because that is so sensitive that it's just too small of a group. Yeah.
And I have to say, from a judicial point of view, I'm very pleased to hear that class is so supportive of the need to even bring someone else in from out of the state in that situation, because we should not be forcing that limited English proficient person to be using an interpreter that they're not comfortable with. So again, if you're the interpreter that's taken off the case because that happens, please don't take it personally.
Mm-hmm. Okay, so let's go ahead and move on to scenario number 4.
I was interpreting in the Family Law Help Center. As I was interpreting for the wife, mother of 2, I caught myself wanting to share with my lawyer what my lawyer said I should do in my divorce. So the person is interpreting for someone else, and the interpreter is trying to fight back the urge to share what his or her lawyer told them in their divorce.
So this situation, I think it falls into that, what we were talking about, the condition arises. So this is more the murky stuff. Yep, thank you. Thank you, Michelle. Let's go ahead and launch the poll. First of all, should I have disclosed that feeling at that time? No, it did not actually interfere with my ability to interpret. Yes, let the court staff know you're no longer objective, or no, you are not in the courtroom, you don't have to say anything. Okay, so yes. Oh, sorry, I didn't finish reading the scenario. Thank you, Lisa. I continued interpreting anyway since it wasn't on the record or anything. Okay, so in that situation, you're not in court. Does the Code of Professional Responsibility even really apply? This is family law counter. There's no record.
I would say yes, it still does. You're still sent there by class. You're still an officer of the court.
Mm-hmm.
And all that aside, I believe every interpreting language has some kind of ethical code that they should be following. And I'm almost certain they would all include something that has to do with you do not insert yourself or your opinion into any interpreting event. And if you cannot refrain, then you should absolutely alert someone. But now you do that self-analysis and you look at what kind of an issue do I have? Is this something I can refrain from participation, or is this something that's going to come out of my mouth or off my hands inadvertently?
Okay. Let's go ahead and close the poll real quick so that we can go ahead and reread this scenario too. There we go. Oh, yep, just the results real quick. No, it did not interfere with your ability to interpret, so you don't have to disclose. Yes, I let the court staff know that I'm no longer objective. So we're kind of like 50-50 right down the middle there. And then one or two people said, you're not in a courtroom, you don't really have to do anything. You don't have to disclose. Okay. Interesting results. Ed, go ahead.
And I've got some people who have very strong feelings here. According to Dean and Pollard's demand control schema, maybe you can talk about what that means, that is an intrapersonal demand. If it hasn't caused a miscue in your ability to work, then it's irrelevant. You only thought about it. That's another comment. You didn't actually say anything. Mm-hmm. And you only had a feeling, but you didn't say anything, so why worry?
Right, right. So at this point, Lisa, do you want to talk about the demand control schema? You really understand it better than I do, so go ahead.
Okay, yes. Yes, we've been talking about that quite a bit, but there are demands within any interpreting assignment, any interpreting interaction, where you have some environmental, they could be environmental, could be the room is too cold, it can be background noise where you can't hear the participants. And then there are the interpersonal where we've been talking about a prior professional contact with an LEP person, one of the attorneys, a witness. And then there's the intrapersonal where inside we are struggling with something, whether it be I just went through a divorce and I know my attorney said that I should do this and this would apply in this case. How can I refrain from saying something? I've experienced, I had a family member killed in a drunk driving accident. Can I interpret for this Dewey? Can I interpret for this trial of a DUI? Those kinds of things, and we need to do those analyses earlier rather than later, so we're not, if we're in the middle of the trial, we don't want to stop. But that demand control, and so then you look at the control and you say, okay, here's the demand. I'm feeling something inside while I'm interpreting this that I want to bring out. Now, what are my controls? I can refrain from speaking, or another, and the controls would be more the choices that we can make in that situation. What can I do about this demand? And one of the other choices would be, I need to, before I let something slip, I'm afraid that it might, I need to just let the court staff know at the counter, the interpreter has personal reasons that I need to not be involved in interpreting today.
Well, what was interesting about the comment we heard from the audience that Ed read was like, sure, you had the thought, something rose up, but you didn't have a miscue in your interpreting. Nothing actually was misinterpreted. I guess when I read the canon number 3, when it says any condition that arises that interferes with my objectivity, it doesn't say that I made a misinterpretation, right? So I don't know at that point if that's a big enough difference that we need to look at that. Yeah, Ed, go ahead.
Comments that are still coming in, and they're kind of at odds with you, Mel. Let me read one. I have feelings all day long, but I do not let them affect my interpreting. I'm in this job because I have feelings and I care, but that does not make me change or sway my interpreting. They're coming in faster than I can get to them. Feeling that is controlled does not need to be shared. Here's an interesting comment. Does that feeling, what you're talking about, does that rise to the level of vicarious trauma?
I think that's probably one of the biggest, elephants in the room for interpreters and staff is the vicarious trauma piece. I think that's why we do this type of analysis, and we just recognize that, oh, I have a sensitivity to this area. Maybe I shouldn't accept this type of work. I mean, that's really the first thing I feel that Canon 3 is talking about. And of course, we have feelings all day long. They don't impact my ability to, do my job professionally and to remain professional, neutral, and unbiased. But when it does rise to that level, how do we even know? Like when I'm interpreting, I'm not outside looking in or hearing my own work. I think that's the slippery slope is I have to do this type of analysis when I'm neutral, when I'm not in the thick of it, so that when I'm in it, I might not see it. I might not know it. Another professional could maybe very clearly see it, but I wouldn't because I'm in it. It's too close. You see, the forest and the trees type of thing.
Mel, I love that because that's exactly what I was thinking. And I actually was in an interpreting situation one time. It was not in court, but it was a legal matter. And I had another interpreter. We were working together, and the interpreter wrote a note to me and slid it in front of me as I was interpreting, and it said, "Watch your expressions." And I thought, wow, I did not even realize what my expressions were doing as I interpreted. Watch your tone of voice. How are you portraying what is being said through the interpretation? And I thought, and when I got that note, wow, that was a real, just a big hit, where I thought, wow, I need to pay attention to this.
I was actually thinking that as an outside non-interpreter, that this question I think should be analyzed in 2 different ways, from an ASL interpreter's point of view and from another language point of view, because I think there's a difference if I'm sitting side by side with an individual and I'm translating a paper, then you all using all of your expressions and all of your emotions to convey your language. And I could have envisioned this being a different answer for an ASL interpreter than for another language interpreter. And maybe I'm wrong, but I watch you all in court, and so much of what you do is your facial expressions. And if you're hurting on the inside because you're personally going through a divorce, how can you keep that from coming out? And if you can, more power to you. But if you can't, I think you need to be watching for it.
And I would say too, if spoken language interpreters, their affect, their register, all of that really impedes. Am I giving enough oomph to a testimony, or am I being, purposely very vague or neutral? I can see it, Judge Weber, in both ASL for sure, but I think in spoken language, if it's there, I think it would come out as well in a different way, though. In a different way. Yeah. Oh, okay. So yeah, I definitely feel like those types of things, we do have to pay attention to them. Again, just to touch on vicarious trauma, we do work with hard work. We do not want to, of course we have emotions all day, and we do have to have a safe place to attend to them. And so that we can continue to do our work. We do not want burnout. This is why we have these ethical webinars, is so we can hear from people. Let's talk about it. Let's get it out there. Let's remind ourselves about where the line is and where the boundary is, so that we recognize when we have slipped a little bit and how much we have to pull it back. Because we want to keep you guys out there working. We want you to be able to perform and take care of yourselves and be healthy. And Ed, we have another comment.
2 comments on that. One, that's right, there's always an emotional debriefing at home at the end of the day, so that's one coping mechanism. Here's another one. I've wondered if my feelings come through in some cases, and even asked neutral parties about it. So asking someone else, getting an outside point of view to help you. So those are
That's
2 coping mechanisms.
That's really interesting too, because we do work in isolation so often that we almost would have to invite in a colleague or somebody to give us that feedback, because we wouldn't get it on our own, because I would say, 90% of my work is alone. So I don't get that feedback. I don't get that note, like Lisa was saying, pushed in front of me, except for that really rare occasion when I have an all-day trial with the team. But I would say 90% of my work is not that. It's short, or if it's such a short trial that they just send one interpreter and they don't give me the team. So I wouldn't get that feedback necessarily. And it's something we have to check and keep monitoring, that we don't have that happen. Yeah. Thank you guys. What a great discussion.
Oh, that actually happened many years ago, but it made such an impression on me. And I don't get to work in a team very often either, but that is the benefit of a team as well. And there are times when we might have 2 interpreters in the courtroom for a short matter, and the judge may wonder, why are there 2? To ensure accuracy, Your Honor. I don't know how that could ever be.
That's all I need to hear. Okay, that sounds great. I like accuracy.
That's what we got.
Well, give it to us. Thank you. Okay, let's go ahead and move on to scenario number 5. Lisa, do you want to go ahead and read this one for us tonight?
I was called to an emergency room to interpret for an LEP woman who was injured. A week later, I was hired to interpret the police questioning of an LEP male suspected of domestic violence, DV. During the course of the questioning, it becomes clear that the alleged victim was the same woman from the emergency room. A few days later, the court asked me to fill a last-minute request for that afternoon to interpret the arraignment of the same LEP male I interpreted for previously on DV charges. Do I disclose?
Let's go ahead and launch the poll on this one before we get into too much discussion. Do I disclose? Yes, to class. I bring it to my scheduler's attention. If they say it is okay to accept it's okay, then I accept the assignment. Yes, about working with the male defendant and the police, I would disclose that. Yes, about the female victim and the male defendant too. Or this one, do not accept this job. None of the above. Yeah. Stay away. Too close. Okay. So this is a good one. Judge, do you have any thoughts on this? This has got a lot of different pieces moving in it, like all the details that you like.
I would run fast, far away. First of all, you are interpreting for the woman who was injured in the hospital. I'm assuming that that was either an interview by law enforcement or by hospital folks in more of a domestic violence investigation, fact gathering for a criminal prosecution. Then you're part of the police investigation when you are standing in to question the male suspect. For me, there's just too much. If I were the interpreter, it would start to make my stomach upset and uncomfortable, and that's always my guide as an ethical issue for a judge for myself, is if my stomach is upset about it. So I think that the best thing would be to pull out of this one completely.
Let's go ahead and close the poll and see what people said before we got the judge to share her thoughts. But
you asked me.
I did. And I think people agree with you, Judge Weber. So we have 27% say, I disclose it to class, and if they say it's okay, then I can accept the job. Yes, about disclosing about working with the male defendant and the police, so that means not sharing about the victim. And then yes to about the female victim and the male defendant, so all of it. And then the last one, just don't accept this assignment. Okay, Ed, go ahead.
And just some comments along the same lines. If you worked with the police, you're a potential witness, run. So that was your response. Judge Weber. Just FYI, I'm sometimes, oh, wrong one. You are too close to the case already. You're not neutral anymore from my point of view.
Mm-hmm. Lisa.
I just want to comment about, and I liked to see that most people picked that last one, run. But the one about ask class about it, and if they say it's okay, go ahead and interpret. And again, we should reiterate that it is incumbent upon the interpreter to do that analysis. It's not class's decision to make. It is the interpreter's decision to make. You can get advice, you can get feedback from class, but really the interpreter is the one that needs to make that final decision. It's not going to be class who is on the hot seat later.
And just because class says it's okay doesn't alleviate the need to let the court know. Right. Judge, I've been sent for this interpreting assignment. I've discussed with Court Language Access Services this potential conflict of interest. They don't believe it's a conflict. I'd like to disclose it to the court. You know, the more information, the better.
Ed, go ahead.
And I'm going to take off my online host hat here and talk about my job as a interpreter analyst. This is actually one of the things I do, and about every other week on average, sometimes weekly, I'll get a call from an interpreter, and very often maybe half of those are about, I was involved in this situation in this way. What do you think about me interpreting? Now they've asked me to interpret some kind of hearing, and we go through this kind of analysis together, the interpreter over the phone, and what everyone has said is right. They're consulting with me. They're using me as a sounding board. I'm maybe pointing out some things they hadn't thought about, or I'm reflecting back what they said, but that decision is that interpreter's. That interpreter has sworn to uphold the code. Me sitting in my office in front of my computer has not made that oath in that specific case. So regardless of how that discussion between class and that interpreter comes out, they still have all the same responsibilities of disclosure and maintaining that removing that impediment if their involvement is an impediment for them actually being neutral and unbiased.
And I think like Judge Rohr was saying, more information is better. Let the court know about the conflict, even if it's just one of these. You know, this scenario is pretty complex, and this is, like I said, we get these from the community. These things happen especially in small towns or big towns where we have a lot of interpreting needs. It's very likely that you could have worked in an emergency room, and then you happen to be the duty interpreter for arraignments the next day, and that name came up in the police report as the perpetrator during the domestic violence interview with the police at the hospital. That could very likely happen. And then what I'm hearing is I think we've come under this disguise of like, oh, I don't remember. I interpret so much I just forget names. Like we're trying to keep people things confidential and let people know that we're going to protect them by this blanket statement of like, oh, it's okay, I don't remember. But what I'm hearing is judges and attorneys keep track. And then they actually run that analysis of what kind of conflict do I actually have? Have I worked with this person? Is this defendant? Is this victim? How are these cases related? And that kind of makes me reevaluate how I go forward with this. Like I might have to pick. I'm going to be a medical interpreter. I'm going to be a legal interpreter, or and then again, just how we disclose that to the court and let them have more information. Mm-hmm. Any other thoughts on that before we move forward, Judge Weber? Nope, we're good. Okay, let's
just run.
Just run. Well, and the code is really clear. It says if you have been in the investigative capacity, it's right there. It tells us. It just says run, run, and run. It's right there. Okay. So, moving on to scenario number 6. This one's mine. I have been called to interpret several times for the same defendant. Each time, the attorney uses my services for a few moments after court to answer any questions and to make sure the next dates are understood. This last time, the attorney asked me, the interpreter, a question about interpreting to help build a better argument for her case. I feel I can maintain my neutrality, but I'm wondering if the defense attorney or the defendant now thinks I'm on their side, quote unquote, and no longer neutral in the eyes of the defense counsel and the client. What do I do? What should I do? Let's go ahead and launch the poll. You want to read the poll, Lisa?
Sure. Do not accept any more assignments from class for this case. Disclose to everyone that there may be an appearance of bias. Continue interpreting professionally.
Mm-hmm. I think now I might add one on this one. Just inform the court that I have a conflict, that I have a potential conflict of interest. Mm-hmm. Mm-hmm. So, yeah. Go ahead.
So, again, we've talked about gradation of the seriousness of this or that, and it would maybe depend on the question that the attorney asked me, how benign it was or how much it was going to. It was definitely clear they're looking to bolster their case in some way. That might affect some of my decision making at that point, but I would not answer the question. I would not give them the information, probably saying something like, that's not my role in this venue. I am here for the courts. And there are resources out there where you can get that information. I don't even know that I'd give them, there was a point where I said that I might even give them those resources, but now I'm rethinking that as well. I'm doing that analysis as well.
Let's go ahead and close the poll real quick and see where people are on this one. Okay, we'll just wait for Michelle to go ahead and close that. Again, I think I like your point. It depends on the question too. So, okay, what do I do? Do not accept any more assignments from class. That's at 21%. Disclose to everyone that there may be an appearance of bias. So just get it out there on the record. More information out there, the better. Let the judge decide. And just continue interpreting professionally. That was 30% almost as well. Yeah, this is a little bit of that sticky one. Like we're starting to cross that line a little bit. You know, in some states, I think it's New Jersey. And I've seen this in Washington State as well. I'd be curious to hear from our Washington interpreters. If you interpret for the defense, you are not allowed to interpret in court as a neutral interpreter. They're very clear about that. And then the state has their own interpreters as well. Like there's no court interpreters for neutrality. Well, I shouldn't say that. I'm sure our Washington interpreters can explain it better. I've only interpreted there a few times, but each side has their own interpreters as well as the court having their interpreters. And they're very clear separation because of stuff like this, right? Like if I've been the defense, attorney, then I really can't be neutral. And they're really clear about that. Yeah, Lisa.
And that's a good point, Mel, but I have, for my own self, I won't speak for any other interpreters, but for my own self, when I work with a defense attorney and a client, and they will say, we're going to need an interpreter in court for this court date, and they'll look at me and say, will you be the interpreter? And I automatically say, no, I won't be the interpreter because I'm here. And that's all I'll say in the matter, just because there is a conflict of interest to me. So regardless of whether it's perceived by anyone else or not, I know that I probably would not take that. I would probably run. Again, there may be the few circumstances where it may be different. I don't know. I know for me personally, though, that's kind of a line that I've drawn. And in that situation, it was just, I didn't take that as being in court. I thought that was just with the attorney. But then going to court after that, if I thought there was a perceived bias, I probably would hesitate to even accept the assignment. In fact, I wouldn't if I was working with the attorney, but you're interpreting at court, or you're interpreting, was that a hallway?
It's a hallway conversation.
Oh, okay. So that is different. I mean, that is a different situation. You are there for the court. Yeah, I would say I'm here for a different role.
Let's go ahead and get some last comments from the audience.
And one comment, attorneys should be taught that we are ethically bound just as they are. So the blame goes to the colleges of law for not teaching their attorneys. The interpreting profession has a special course. I'm sorry, I missed that last part. It goes to the colleges for not teaching them that interpreters have their own set of ethics.
When I first heard about this scenario, my first response was shame on the lawyer, because I think this is a lawyer issue and not an interpreter issue. I mean, it is an interpreter issue because of the effect.
Here's a statement, but you can kind of look at it in terms of a question. Sometimes attorneys just need some feedback on cultural issues or whether the interpreter is getting through to the defendant. Is that appropriate?
Judge Weber, do you have any thoughts on that?
I think those are two different questions. The second one is the person getting through to the defendant or the limited English proficient person. I think that's an okay question. I don't have a problem with that, because that's are you establishing communication? Are you able to communicate? The first question, I think in this scenario, that depending on what the question was that the lawyer asked, they're looking to the interpreter as a potential cultural or linguistic language expert. And I think that then has a part of the defense team that takes you out of a role of interpreter and may well have morphed that. And to be really honest, I'm learning as I'm doing this presentation, as I always do. And I think an hour to an hour and a half ago, I would have felt okay about an interpreter being the interpreter for an office appointment and then doing the interpretation in the courtroom for a brief matter. And I think I've completely switched my opinion on that, just working our way through these conversations, just because of these potential conflicts of interest and this kind of a question. And I think the Washington model sounds superb. Those of you that work in Washington are really lucky.
Mm-hmm. They are fortunate. And best practices versus functionality, I think we often get caught in that slippery slope of trying to be good resources of money, and then best practices as well. And Judge Robert, it hit me when you said that, like, sure, somebody says, so, is it normal for you guys to have two interpreters? And the interpreter answers, yes or no, and then not even thinking, like, but that could be viewed as now you're an expert witness, like, like those potential, like, or whatever the question might have been from the attorney. And if it's about interpreting, it's about our profession. I'm just looking at the scenario that they were using it to bolster her case. I hadn't thought about, like, those little things that I don't even think of could make me be viewed as an expert witness in that interpreting professional question. I hadn't thought about that.
I was interpreting this more as a question to bolster the case, and not, so when you're in court, do you have two interpreters? And that's really interesting. And what does that sign mean?
Okay.
I think if you took it to a much more case-specific, working as an expert, that you're going to be providing information for their case, that's different than just learning about interpretation in the courtroom.
So like more cultural or something specific. Mm-hmm. Hadn't even thought about that, though. So that's a good piece to think about. Yeah. Any other comments, Lisa?
Yeah, and I think this one, of course, was in the hallway, so that makes it an even more different situation, because you're already kind of there for class for the court. Mm-hmm. You're not there for the attorney's office visit.
Mm-hmm. Right. And so then just to, as we finish up for tonight, what I'm thinking about with this one too is, we've talked about this too, is like what's privileged versus what's not privileged communication. So if I now feel like I have interpreted, let's say this is, this court cases go for a year and a half. So you add those 10, 20 minutes up over time, I could really potentially have been a table interpreter, or that, person's interpreter. And if that potential bias is there, then I do have a duty to just let the court know that I have a potential perceived, I feel like it's the perception on this one, that people see me in the hallway interpreting for this person extensively over a long period of time, and then I go into court and everybody smiles at me because I now have enough of a relationship with them that it seems like that I'm a friend. And that goes back to really clear with Canon 3 about what is an actual conflict of interest for us. So, again, some major takeaways from tonight's conversations. I'm so excited. Thank you, everybody. Let's go ahead and we're going to start our goodbyes. But again, the review, the takeaways that I have from tonight's discussion, Judge Weber sharing with us that attorneys and judges do this analysis. They are trained in it. They have apps for this. They have computer programs for this that track if there's actually a conflict, and that a potential conflict of interest is language that the courts know about and are familiar with and want to hear from us from. So when we look at tonight, by the end of tonight's webinar, you will understand Canon 3, impartiality and avoidance of conflict of interest, of the Code of Professional Responsibilities for interpreters in the Oregon courts. I feel like we have done that very well. Thank you. Through our objectives tonight, through our exploring Canon 3 about impartiality and avoidance of conflict of interest and why that's important to the court and why the court wants to know that. Thank you, Judge Weber, for really giving us that perspective of the court and why it's so important and that it's you know, anticipated that they want to hear from us. And again, thank you everybody out there for tonight's discussion. Michelle is going to launch a link for our